Welcome to UXL, where you can learn new skills anytime and anywhere. Visit uxl.com to explore our full course selection. This lesson is part of a larger course. Check the video description below for a link to the full course where you can enroll. If you enjoy our content, please like and subscribe. For your convenience, the course cover displayed on your screen provides the complete course title and lesson title. Let's proceed with the lesson. Lesson: California Fair Employment and Housing Act. The California Fair Employment and Housing Act, codified under the California Government Code /F 12900 ETSEEC, is a comprehensive statute designed to safeguard employees from discrimination, harassment, and retaliation in the workplace. Enacted in 1959 and subsequently amended to bolster its protections, FEHA remains a cornerstone of California employment law, embodying the state's commitment to fostering an equitable working environment. This legislation is instrumental for HR professionals, particularly those pursuing the PHRca certification, as understanding its nuances is crucial for effective harassment prevention and promoting appropriate workplace conduct. PHRca prohibits discrimination based on a wide array of protected characteristics, including race, color, religion, sex, gender identity, gender expression, sexual orientation, marital status, national origin, ancestry, disability, medical condition, genetic information, age, and military or veteran status. This broad spectrum of protections ensures that all employees have the opportunity to work in an environment free from bias. For instance, an employer cannot refuse to hire or terminate an individual based on their race or gender identity. The Act also extends to cover harassment and requires employers to take reasonable steps to prevent and correct wrongful behavior. The legal framework provided by PHRca is more expansive than federal laws such as Title VII of the Civil Rights Act of 1964. While Title VII prohibits employment discrimination based on race, color, religion, sex, and national origin, PHRca encompasses additional categories such as gender expression and genetic information. This broader coverage under PHRca is critical in ensuring that California workplaces are inclusive and diverse. For example, gender identity and gender expression protections under PHRca mean that employers must accommodate the needs of transgender employees, including allowing them to use facilities that correspond with their gender identity. The enforcement of PHRca is carried out by the California Department of Fair Employment and Housing, which investigates complaints and can bring civil actions against employers who violate the law. In 2020 alone, the DFEH received 22,584 employment-related complaints, highlighting the ongoing relevance and need for robust enforcement mechanisms. These statistics underscore the importance for HR professionals to be well-versed in PHRca's provisions to mitigate risks and ensure compliance. Preventing harassment under PHRca requires employers to implement comprehensive policies and training programs. Employers with 5 or more employees must provide at least 2 hours of sexual harassment prevention training to all supervisory employees and 1 hour to non-supervisory employees every 2 years. This mandatory training must cover key topics such as the definition of sexual harassment, the types of conduct that constitute harassment, strategies for preventing harassment, and the remedies available to victims. By educating employees about their rights and responsibilities, these training programs play a pivotal role in cultivating a respectful workplace culture. Retaliation is another critical aspect addressed by PHRca. The Act prohibits employers from retaliating against employees who oppose discriminatory practices, file a complaint, or participate in an investigation or lawsuit under PHRca. Retaliation claims are among the most common types of employment-related complaints filed with the DH. For instance, an employee who reports sexual harassment should not face adverse actions such as demotion, termination, or unfavorable work assignments as a form of retribution. Ensuring protection against retaliation is essential for encouraging employees to come forward with their complaints without fear of reprisal. PHRca also mandates reasonable accommodations for employees with disabilities. Employers are required to engage in an interactive process with employees to identify and implement effective accommodations unless doing so would cause undue hardship. This may include modifications to the work environment, providing assistive devices, or offering flexible work schedules. The goal is to enable employees with disabilities to perform the essential functions of their job. For example, an employee with a mobility impairment might require an ergonomic workstation to facilitate their productivity. Failure to provide reasonable accommodations can result in significant legal and financial repercussions for employers. An illustrative case that underscores the implications of failing to comply with PHRca is the landmark decision in Janowitz v. L'Oreal USA, Inc. In this case, a sales manager was terminated after she refused to follow her supervisor's directive to fire a sales associate based on her appearance, which she believed to be discriminatory. The California Supreme Court ruled in favor of the plaintiff, holding that an employee's reasonable belief that an action is discriminatory is sufficient to support a retaliation claim under PHRca. This case highlights the importance of fostering an ethical workplace where employees can voice their concerns without fear of retaliation. To ensure compliance with PHRca, HR professionals must adopt a proactive approach. This includes conducting regular audits of workplace policies and practices, providing ongoing training, and fostering an inclusive culture. By doing so, employers can mitigate the risks of discrimination and harassment claims and promote a positive working environment. For instance, regular climate surveys can help identify potential issues and address them before they escalate into formal complaints. Moreover, establishing a clear reporting mechanism and ensuring that all complaints are thoroughly investigated and addressed is crucial for maintaining trust and accountability within the organization. In conclusion, the California Fair Employment and Housing Act is a vital piece of legislation that provides comprehensive protections against discrimination, harassment, and retaliation in the workplace. For HR professionals, particularly those aiming for PHRca certification, mastering the intricacies of FEHA is essential for effective harassment prevention and promoting appropriate workplace conduct. By understanding the broad scope of protections under FEHA, implementing robust training and policies, and fostering an inclusive and respectful workplace culture, employers can ensure compliance and create a positive environment for all employees. The ongoing enforcement efforts by the DFEH and landmark case law underscore the importance of adhering to PHRca's provisions and the potential consequences of non-compliance. This concludes the lesson. We trust you found this video informative and engaging. To enroll in the complete course, please use the link provided in the description below. At UExcel, we are committed to your learning journey. Each course offers a certificate of completion, online support, and downloadable resource files to enhance your experience. If you found our content valuable, we invite you to like this video and subscribe to our channel. Thank you for joining us, and we look forward to supporting your continued pursuit of knowledge.